boy, did you listen to Sharon Kaskowski talk about what you got to do? Like this technology is way easier than having people come in your office and doing all those things. So glad I chose this route for now. Anyhow, so I'm doing my ACTLA talk of the day. It's just really to go over the basics because I know, with us being at home, looking after our kids, or being at the home office, and you got to find all your notes and where's this thing and where's that thing. It's just in one spot. So this thing has links. You can pull this up. So when you're dealing with the situation where your client's saying, I can't afford to pay for this treatment, or that you want them to get the benefits because the defendant's going to say you should have applied for those benefits. I want a deduction, whatever it is. So it's important under the under the laws now that if there's benefits, you should apply for them because the other side may want to reduce your claim by that amount. Even if you can't afford them and don't think it's worth the hassle. So we'll just go through a checklist, and I kind of put them in the order that I think of them in, and so I hope that's useful to you. So I want to first say, so it's payment for virtual treatments. So it's presented by me, but I got to give a special thanks to Walter because Walter is always the guy with the best precedents. And so I've attached two that are not going to be shown today. They'll be identified, and you'll get that with the package because my PowerPoint is going to go out shortly. And so, yeah, so here it'll get you to the benefits regulation if you want to look up Section B. So it's right there. Then for the medical payments, it just goes through the different things. So you have to figure out whether it's something that falls under the diagnostic and treatment protocols regulation because it's a minor injury, or whether it may be not that. So I've got all the words there, and you can go through all that. It's handy. I've excerpted it, but we don't need to go through all that today. I didn't look at who signed up today because we're doing them on fairly short notice. So I'll do it at a high level, but everyone's always invited to email me or call me if they have any questions. So then there's going to be those ones to which the diagnostic and treatment protocol don't apply, or there's certain injuries that are outside of it, or it's just not there whatsoever. And the key point is you get the Section B adjuster. So this is all they get. Like we got the whole case to deal with, and this is what they look at. So you have to really know it. And if you're going to get something to get those benefits approved, rather than say, get a note from your doctor, some of them have to see the words that's right in here. So give it to the doctor, give it to your client, call the doctor, whatever it takes. And so all reasonable expenses, well, that's an interpretation as a result of the injuries. So that'd be related. They can't be related to nothing. But these are what's required because of the injuries in the accident. So the words are kind of there to put in the note, and it's got all the different things it covers. But just remember, in addition, it's for other services and supplies. So that could be a whole range of things you might not think of. Okay, so it could be that they're going to yoga because that's prescribed. It could be that they're prescribed, I don't know, some home TENS machine. Who knows? So there's other services and supplies. The trick is, in the opinion of the insured person's attending physician, right? So your attending physician, and usually they'll take it from your treatment provider, and in the opinion of the insurer's medical advisor. So that's where they say, that's expensive. I'm going to send you to my guy just to make sure. Okay. So, and it has to be essential, right? Blah, blah, blah. Essential for the treatment. So they're going to treat it, or they're going to rehabilitate them. So those are the kinds of things that you're thinking, what is it they want? How do I get this? Because people will say, well, I got a new mattress, or let's think what it is. And of course, the Section B goes, I'm not covering that. But you get a nice note that explains why in the circumstances that might be reasonable, you'll have better luck. That might have been the best example. But that's the thing to look at and what I do is for my clients is that I say, don't just, because they'll say, oh, I don't have coverage anymore because they think 21 treatments is all you get. Well, no, you got 50,000 with certain limits. So there are limits for that 50,000 for $750 for chiro, $250 for massage, $250 for acupuncture, I think. But in addition, they don't know that they can come back for more, up to 50,000, if they just exhaust their other benefits. You have to explain it because the insurance company gives them a big, long thing, and especially if you got a brain injury or you get you got so much going on, you don't even understand it all. So you have to make sure, in a nutshell, you've got that. Okay, and so you go to your Section B benefits, and if there's a minor injury involved, you get your 10 or your 21 treatments, and people think, I'm done. And it's like, well, no, go to your other benefits. And so they got to go through all their benefits. So they may have benefits through their parents, their spouse, uh, I don't know. So you have to go through those benefits, and then you return to Section B benefits. And again, in either scenario, when you're going, I say to my client, I say, look, get me a letter as to why they're denying it. Because I try. Some clients you have to do all their benefits for them. They got a head injury or whatever. But otherwise, if they're independent adults, I consider it part of the rehabilitation. You deal with the paperwork if you can. And so, because there's always a lot of things to deal with in personal injury and on cases. But I say, get me a letter, because then they'll get me a letter, and the letter, the adjuster has to say, well, I can't just say no. And I always tell the Section B I'm involved, right? So I'll send a letter out to them so they know I'm there. And then they'll say no because you forgot to give me this. So I'm saying, well, give them that. And then at the end of the day, if you've got a clear denial and there's nothing you can get around, you can make the judgment call as to whether you have done enough and maybe you go somewhere else, or whether you pursue a lawsuit, and then there's some risk of that with raised judicata and all those kind of things. So it's a decision you need to make. Next, I look at, okay, so you've got the benefits, then there may be assignments. I never say go get an assignment from your doctor, but sometimes a treatment provider has treated someone for so long and they don't mind, in the occasional case, helping somebody out, right? So they may have an assignment, and in the materials I'll give you Walter's, because mine's not as nice a precedent. And so then you got to think, well, consider getting advances on settlement proceeds. Again, here's the Insurance Act that it falls under. You can just link to it because it'll be a PDF that I send to you, and then, or that Sandy will send to you. And then you've got the Fair Practices Regulation, right? So you can link to that. So I've just excerpted out some parts for this. And it just goes through what you need to do in getting an advance payment. Again, we are limited time. You can read through that, but I underlined what it is. The court is satisfied, so you may have to threaten court. I will send a letter first with all the evidence for my application, because then they know you're ready to make it, and that usually can avoid it. And you have to figure out what you need. So you got to go through the benefits. You got to, assignment, maybe something after, back and forth. You make the decision. It's all fact specific. But you have to be, the court is satisfied that, and get this in your materials, right? Like, as a result of the injuries of the claimant is unable to pay for the necessities of life. So it's as a result of the injuries the claimant is unable to pay. Not that they were already couldn't pay, but there's a or, and that's where the payment is otherwise appropriate. So and how can you show they can't pay for the necessities of life? Well, it's like, if you're going bankrupt, here's my income, here's my expenses. The more of that you can pile up with all the unpaid bills, the more convincing a case it is, because they know you can just go to court tomorrow. But if you just say, could I have an advance? It may not work. So that's the kind of things to do. And don't, you tell your client says, I need an advance. Well, you get me the stuff, and if they really need it, they'll do that work. Otherwise, they'll find an easier way to get you the materials, or get the money they need, or take the treatment they want. That's just my opinion. There's ways to do it. And then you can consider government benefits, right? So there's, assured income for the severely handicapped. I've met people that could have been on AISH and they can't pay for treatments, but they couldn't figure out the paperwork for AISH. So you have to think of those things, like maybe they fall under AISH or CPP or whatever, or social assistance. I don't know if that's still what it's called. Alberta Healthcare sometimes will cover physiotherapy in a hospital. So I've had a lot of clients experience that, because they'll say, oh, this person can't afford it. So there's different things where Alberta Healthcare will actually pay for it. And then this is one from Walter again. There's some materials that you'll get. And now there's some, Government of Canada supports under COVID and that kind of thing. And so that's an excerpt that he got and provided to me, and I'll give that to you. So I may have talked too fast, but I see that it's almost the end of time. So I apologize. It's all here. And if you have any questions, then let me know, and then we're on time and you can get back to work.